Well, absolutely. Texas is what's called a comparative fault state, which means that the fault of the different parties involved in a wreck are compared with each other. So, for instance, if a car hits a pedestrian in a roadway and the case is tried, a jury would be asked to assess fault based on a percentage basis to both the driver of the car and the pedestrian. So, for instance, if the car driver was determined to be 80% at fault for causing the incident and the pedestrian was 20% at fault, then the pedestrian's award of money would be reduced by his or her 20% of fault. Well, of course not. Sometimes pedestrians do stupid things just like anybody else. If someone's crossing in the wrong place or isn't following other safety rules, then the pedestrian certainly could be at fault. On the other hand, sometimes drivers aren't paying attention. Maybe a driver runs a red light or a stop sign, then the driver would be at fault. So pretty much like any other situation, just depends on the particular facts of a particular case. Well, generally I would advise people that it's not a good idea to talk to the other party's insurance company. It's really not a fair fight in my view. You're dealing with a professional claims adjuster and you probably aren't one. So they know what to ask and how to ask it. They're probably recording you. They'll kind of chat you up and maybe your guard's down and you'll tend to agree with something just to be nice when that's not necessarily what happened. So it's rarely a good idea to talk to the insurance adjuster for the other driver.